Good morning, AP Gov, and it's time to switch branches. And now we take a look at our third and final branch of the Constitution, and that is the judicial branch. And good news for us, there's not a lot to go over for this one just because it's such a small branch. So here we go. Article 3 is the judicial branch, so you need to add that to your chart somewhere. Article 2 was the executive. Article 1 is the legislative. You just need to have that by memory by now. In Article 1, Section 1, Article 3, Section 1, you'll notice a couple of things that are different. First of all, there are no requirements. And so everybody that's listening to my voice right now could actually be selected as a Supreme Court or federal judge. Except for the fact that we would never get past the Senate. And there are no requirements. You don't have an age, you don't have a citizenship, you don't even have to have a law degree. But what it does say is that the Supreme Court was created by the Constitution, and then the inferior courts will be created by Congress. And so we'll go over this in just a second. We'll take a look at the three levels of the judicial branch. And which ones were created by the Constitution, which we now know is the Supreme Court, and the other two which were created by Congress. We also have the fact that judges have their jobs for life as long as they have good behavior, which means that they can be impeached if they do something wrong. But the fact that they have their jobs for life is known as judicial independence. And you need to jot that down in the box about judicial terms. Judicial independence basically means that once they have their job, they don't have to worry about being too liberal or too conservative and being fired for that because they can't be fired. And so this is a protection so that conservative presidents don't fire liberal judges and liberal presidents don't fire conservative judges. So judges can focus on what they believe the law means rather than what's popular. We also don't vote for judges because then they would just do what's popular rather than what's right, and that would potentially impact society. As we move on, we see that there is the word jurisdiction that pops up a couple of times. So you need to define jurisdiction as the ability to hear a case. That's the simple definition, the ability to hear a case. And as you see, the Constitution creates two jurisdictions. Original jurisdiction means that you are the first court to hear the case. You are the original court to hear the case, and that's why they come up with original jurisdiction. And so this would be your bottom level courts. The Supreme Court does have original jurisdiction in 4 cases, and that's described up here, but you don't need to know that for AP, so I'm not going to go over it. But if you really were interested, you would read right up here, and it would explain how cases can go straight to the Supreme Court. The second type of jurisdiction is called appellate jurisdiction. Appellate jurisdiction means you are going to hear the case on appeal, and that's where they get the appellate from. So the fact that it's on appeal means that it's already been decided at a lower court, and now an upper court is deciding whether or not the correct decision was made. That is appellate jurisdiction. 99.9% of the cases that go to the Supreme Court, they get through appellate jurisdiction. So you need to know the difference between original and appellate jurisdiction. You'll also see that all trials have to have a jury, and that is the decision of the criminal. So if you are a criminal, you get to decide whether or not to have a jury or not. Most of the time you decide to have a jury because they're easier to sway. And you see that the crime shall be held in the state where you commit the crime. So if I am a Missourian, but I commit a crime in Florida, my trial is in Florida where I committed the crime, not in Missouri where I am from. And then finally, it gives us a definition of treason. Treason is when you levy war against the United States or you give our enemies aid and comfort. So that is the definition. Levying war, like picking up guns and actually shooting at American soldiers, or giving our enemies aid and comfort. So if you write a check to Al Qaeda for $50,000, that is giving them aid. Or if you allow them to stay at your house so that they can plan a terrorist attack against St. Louis, that would be giving them comfort, and you could be charged with treason. The reason why it's so hard to find people guilty of treason is because you also have to have the testimony of two witnesses. So they have to have seen you do either the actual levying of war or giving our enemies aid and comfort. And sometimes that just doesn't happen. You just don't have two witnesses that can testify to that. And so you have to bust that person on a lesser charge. And it also says that Congress shall have the power to declare punishment, and the punishment currently is death. The last person that was put to death for treason, I believe, was the Rosenbergs from World War II. But we have had American spies caught and busted for treason, and they have gone to jail as well. But you can give them the death penalty. Where is judicial review in all this? Remember, it's not in the Constitution. We're going to find out this unit that Marbury versus Madison, which is a famous Supreme Court case that you're going to have to know, was the reason why the courts have judicial review. But remember that judicial review is nowhere in the Constitution. Here you go. This is the different systems. In the United States, we have both state court systems and federal court systems. How do I know which system I go into? That can be answered by what kind of crime did you commit? Did you commit a state crime, which is what most people do, or did you commit a federal crime? If you committed a federal crime, then this is the level that you go through, and you need to make sure that you know the 3 levels of the federal court system. So at the very bottom, you have district courts. There are 94 district courts throughout the United States. I'm going to show you a map about this in just a second. And each of those courts have original jurisdiction, which is what the O stands for. So that means that these courts are the first federal court to hear your case. So if I break a federal law, say I kill an FBI agent, or I counterfeit American money, both of those are federal crimes, and so I would go into the federal court system. If I did not like the decision of the district court, then I could appeal my case to the circuit courts, and those are geographically based, but there are less of them, and you'll see what the different circuits are and which one Missouri is in. But I could appeal my case to the circuit court. If I didn't like what the circuit court had to say, then ultimately I can appeal it all the way up to the Supreme Court. Circuit courts have appellate jurisdiction only, and the Supreme Court, remember, 99% of the time has appellate, and just a small percentage has original. If I commit a state crime, like I commit murder against, Mr. Anderson, then I would start at the state trial court. If I didn't like the decision there, I could appeal it to the Court of Appeals of Missouri. If I didn't like their decision, I could appeal it to the Missouri Supreme Court. And if I didn't like their decision, I could then finally go to the U.S. Supreme Court. So what you need to know is that either system does end in the U.S. Supreme Court. But we do have 2 systems of courts in the United States, state and federal. This is an example of federalism, once again, in our system, and it just depends on what crime you commit. Here are the 94 district courts. So if I break a federal law in Missouri and in St. Louis, then I will be heard in the Eastern District of Missouri. There's also a Western District of Missouri. And you can see that Missouri is split into 2 districts. If I don't like the decision of the district court, then I can appeal to the circuit courts. And you can see that Missouri is in the 8th Circuit, which groups up Arkansas, Iowa, Minnesota, the Dakotas, and Nebraska. So any of the federal courts that are heard in these 7 states, if you appeal it to the 8th Circuit is actually located in St. Louis. And so they would hear all of the federal appeals of those 7 states. And then if you didn't like what the 8th Circuit had to say, you could then appeal it to the Supreme Court of the United States. Obviously, the 5th Circuit of the United States and the 11th Circuit are more conservative. The 9th Circuit is considered the most liberal, along with the 2nd Circuit. And that makes a difference just because if you have a federal crime that is happening all over the United States, like let's say you want to stop smoking and you want to ban smoking, you could, because smoking happens all over the United States, you could pick which circuit you want to start in. Most everybody who wants to have a liberal outcome will start in the 9th Circuit. Everybody who wants to ban abortions will try to do it in the 5th or 11th Circuit, where it's more conservative. Okay, now you need to go to the section of your worksheet that I told you not to do, which is the criminal and civil law section. And I wanted you not to do it because there's no way you were going to be able to get this without explanation. So there are 2 types of law in the United States. There is criminal law and there is civil law. For the definition of criminal law, jot down that it involves an action that is considered to be harmful to society as a whole. And there are literally like 18 or 19 different things. This is like murder, rape, larceny, which is stealing. You've got arson, which is fire. Basically, any of those are considered criminal actions. If you take an action against somebody that is harmful, you are a criminal. Now, as the victim, you should not have to spend your own money to see your perpetrator, your criminal, go to jail. That should be done by the government. And so when we prosecute criminals, the government does the prosecution. They are the lawyers. They take care of all of the costs because you shouldn't have to as the victim of the crime. And so the prosecution is always the government in a criminal case, and then the criminal is known as the defendant. And so the defendant would have to either hire their own lawyer or they could get a public lawyer for free, but those are tremendously overworked. They have a huge caseload. They have literally hundreds of criminals that they're trying to argue for. And so you're going to get a much better attention if you can hire a private attorney. Once you go to trial, in order to be found guilty, you have to be considered guilty beyond a reasonable doubt, which means that the jury has to have no doubt in their minds that you are guilty. If all 12 of those members find you guilty, then you are guilty as charged. If all of them find you innocent, then you are innocent as charged. And if it's broken up into any other fraction, you have what's called a hung jury. In the United States, for the most part, you have to be found guilty by a unanimous decision. And the reason why we have such a high standard to set is because the punishment in criminal law can either be the death penalty in certain cases, which is obviously the most serious punishment, or another very serious one is you go to jail. You lose your freedom for a certain part of time. You can also lose money through fines. You can also get community service, or you can get probation. So that is the criminal section of our legal system. However, sometimes we just get into accidents and nobody broke the law, but we got to figure out who is liable for the destruction. So for instance, if I'm leaving Parkway West and I'm pulling out of my parking space and Mr. Anderson's not paying attention because he's doing a frickin' science experiment in the car, and he bashes into me while I'm backing out of my parking spot, nobody broke the law unless one of us was drunk or one of us was on drugs, which that's not going to be the case. So then the answer is just who caused the accident and who has to pay for the damages. And that's what we mean by involving private disputes between people or organizations. And what the dispute is about negligence or liability. Who caused the accident? Who has to pay? And so I could sue like McDonald's, for instance, if there was a mouse poop in my hamburger. And so therefore they made me an unhealthy piece of food. And so I would sue either Mr. Anderson or McDonald's. And so I would be the plaintiff, and Mr. Anderson or McDonald's would be the defendant. If it was for a large amount of money, then we would have to go to small claims court if it was a small amount of money, or we would have to go to a regular court if it was a large sum of money, and we would both have to get lawyers. Judge Judy is a small claims court. You notice that there are no lawyers there, and that's because the monetary, what they're suing for, is less than, I think, $5,000. So then when we go to trial, who wins? The person who wins is who has the majority of evidence on their side. And so the jury has to determine who has more witnesses, who has more evidence. Is it the plaintiff? Is it the defendant? And in civil cases, you can only be the only punishment is money or action ordered to stop or not stop. So for instance, if I was teaching in Parkway with a big cross on my neck and that offended some students, then the students could sue Parkway, and or I could be told to stop wearing the necklace, and so then I would sue Parkway saying I have a First Amendment right to wear the necklace, and so it would be Chazen v. Parkway, and then Parkway could be ordered to let me wear the necklace, or Parkway could be or I could be ordered to stop wearing the necklace. And so those are the major differences between civil and criminal. And there is both federal criminal and state criminal, and there is both federal civil and state civil. So there literally are all sorts of different levels of our legal system. Here is just a little graph about how you are found guilty in criminal cases. You have to be beyond a reasonable doubt. You have to have 100% people think you're guilty in order to be found guilty. However, on the civil side, you just need 51% to be found guilty in civil cases. All right, so we're going to stop here, and we will pick up tomorrow with the look at how the Supreme Court takes cases, and then we'll take a look at some Supreme Court cases, and then we will be done. So thanks for hanging in there. Have a great day.